Thank you. Please be seated. This is the time set for oral argument in CV15 versus Anderson, our cause number CV150567. Let's go ahead and begin with introductions of counsel for the appellant.
Martin Ben and Donna McDaniel for the Stefanoviches.
Thank you very much.
Benjamin Gottlieb for Michael and Robin Anderson, the appellees.
Great. Thank you. Thank you all for joining us today. Let me go through a few preliminaries. Each side will have 20 minutes. If the appellant would like to reserve some time for a rebuttal or a reply, if you go to the podium, and when you first go to the podium, let us know how much time you'd like to reserve. We will try and honor that and not poach on your time in your opening remarks. We are recording the proceedings today, both visually and audio, and the recordings will be available, I believe, on our website and on YouTube in a few days, so you can please note that. Because we are recording your comments today, if you would please, when you go to the podium, please restate your name. That way, if someone is listening, they'll be able to track the voice. Let me advise the parties that we have read closely your briefing on appeal. We have reviewed pertinent portions of the record, and the three of us have met and conferenced the case. We are familiar with the issues and the arguments you've raised, and you might wish to take that into account in your remarks today. So with that, let's go ahead and begin from the appellant.
Good morning. I'm Martin Ben for the appellants, and I think I'd like to reserve about 10 minutes. I want to focus immediately and directly on the ARS 33-1376 claim. In our view, what happened is the judge did not follow the law. It's quite clear when we look at the jury instruction that it does not track the law.
Mr. Ben, let me jump in
Yes.
and ask, where in the record can we find your objection to this specific jury instruction?
We have objected to it through the Rule 50 motion.
But I'm talking about before the instruction was given so that we can determine whether the objection was waived or preserved.
We objected.
And maybe you can look in rebuttal, but I need a
Okay.
specific record site
Okay.
that I can look at.
Yep.
Because if it's been waived, we're probably not going to go down the substantive course.
I agree, Your Honor.
Yeah.
No, we objected to it and objected in we filed our first Rule 50, our renewed the motion, we argued it during jury instructions as well. Ours was denied.
And if you can give me
Okay.
that record site, that's
Okay.
what I'm looking for.
Let me follow on with Judge Downey. Now, perhaps in rebuttal, you'll let us know where in the record you objected to the jury instruction, but we do not have a trial transcript. And at least based on our review of the record, or at least I'll say my review of the record, I could not find any evidence of an objection to this jury instruction, either preserved in the minute entry, such as let the record reflect in the settling the jury instructions, counsel for the Stefanoviches objected to the court's instruction, and so forth. I don't see anywhere. Now, I understand the issue was raised in summary judgment. I do understand
Yes.
that. I also understand and appreciate it was raised, I believe, in a Rule 50 motion. But I don't see anywhere in which there was an actual objection to the jury instruction given. And if I'm right on that, let's just assume for the moment I am. What then have your clients preserved this issue for appellate review?
We objected to the jury instruction when we discussed jury instructions.
If we don't have a transcript, if we don't have a transcript, it does not exist for us.
We objected, and we have the summary judgment motion, the Rule 50 motion, the renewed Rule 50 motion regarding this instruction and the claim in and of itself.
Well, it was Rule 50 was claiming there was nothing to submit to the jury. It wasn't that the instruction was wrong. And that's a pretty important distinction, and that's why Judge Norris and Judge Downey are. But we'll wait to hear in your reply where that was preserved.
Thank you. In and of itself, I still want to focus on that statute and why it doesn't apply. The claim in and of itself requires two things. It says the tenant may obtain injunctive relief to prevent recurrence of conduct or terminate the rental agreement. That's the remedy that the tenant has. And again, there's the landlord has the same remedy, but The idea is it can obtain injunctive relief or can terminate the rental agreement. It doesn't say or sue for damages. In here, we didn't have that. That claim in this case was decided essentially by the jury in our favor. Here, the tenant didn't obtain injunctive relief and didn't terminate the rental agreement. In fact, there's a tenant cites a letter that says we have surrendered the premises. But the claims that were brought in this case related to the rental agreement, and was found that in our case, plaintiffs prevailed and plaintiffs were awarded all of the rent. There was no termination of the agreement. The agreement ran and we collected all of the rent. That's what we were awarded. So there was no sense in this case that there was a termination or a rental agreement. Tenant never pursued either of these two remedies, and they're exclusive, and the statute has to mean something when you pursue something like this.
Now, the Andersons counterclaim for breach of contract,
Right.
and the jury did not find for them on the breach claim. Is that correct?
That is correct.
And the essence of the Andersons' breach claim was what?
That they were not allowed to sublease.
Oh, okay.
They lost the sublease.
But they did not assert any type of breach claim based on the unauthorized entry into the house.
Purely statutory.
It was all based on statute.
Yes, it was, Judge. Their other claim that was not, Judge Ray didn't even present, was the breach of covenant of good faith and fair dealing. That was apparently another tort sort of claim, and that was also, in fact, there were no instructions even given on that.
Let me raise a question about the statutes here that are under the Residential Landlord Tenant Act. I believe that ARS 331343 deals generally with landlord access. And generally speaking, it says landlords shall not access the property, the rented property, without notice and at least 2 days' notice and so forth, without permission. Then, of course, we have the other statute that allows for a remedy for abuse of access. If a tenant does not pursue injunctive relief and does not terminate the lease, but let's just say wants to sue for damages, is that claim by itself preempted by the Act? I mean, for example, I'm a tenant and you're my landlord, and I don't really want to get injunctive relief, and I don't really want to terminate the lease. I'm happy where I am. I just want you staying out of the house. Okay. And instead of going for injunctive relief, I just decide to sue for damages. Can I do that?
I don't think so. I don't think that's what 1376 authorizes you to do as the
So
tenant.
you're saying that that provision preempts any other type of remedy that I, the tenant, can pursue?
It identifies the remedy. It's a specific remedy, and that's the exclusive remedy. Yes. Yes, Your Honor.
What if I'm then I have a tenancy for a year, and the landlord has made the unlawful access or the unauthorized access at the end of month 11. So really, I'm going to be gone in a month. We're almost at the end of the lease term. Injunctive relief is really not very appropriate there. I'm not even sure a court would grant injunctive relief given that late timing. Termination of the lease probably doesn't make sense because I'm going to be out of the property in 2 or 3 or 4 weeks later. So and on the face of the statute, it doesn't say it's exclusive. So in that situation, I'm the tenant. I have no remedy. I mean, you're the landlord. You breached the covenant of quiet enjoyment, but I have nothing. I have no remedy.
No, I think the remedy is the termination of the lease. I think
So I
that's
have to
very
get
clear.
out 3 weeks early, even though I was going to get out. I was going to leave in 3 weeks.
Well, I think that's right, Judge. That's the way the statute's written.
But where in the statutory language, and this is a uniform act, I believe, where is there any authority that the remedies that that statute requires me to pursue those remedies and no other.
I don't think that's in the Act, Judge, but I think that's in our case law. I think that's when
What's the case that says that?
I think we look at the McNamara case. It's McNamara versus Citizens Protecting Taxpayers is one of them. And I think, if you'll give me a moment.
That's not a case involving landlord-tenant
No, it's
law.
not involving landlord-tenant, and there aren't any specific landlord-tenant
Right. That's
cases
just
that
a
I can
case
find.
explaining what we should do when we construe statutes.
That's exactly right. Those are the
Okay.
only cases I'm going to be able to cite,
Okay.
Judge. And those are in our reply and in the brief itself.
Thank you.
Counsel, could you address with respect to the exclusivity of the remedy in 1376, how that squares with the sort of general purposes, the 1303, 1304, 1302, that appear to reference common law concepts to supplement? In other words, I think your argument is if it's not in 1376, you don't have it.
Well, I think that's a matter of statutory construction, Judge. We've got the statutes that are very specific about what remedies a tenant gets, and there's doubling of rents and certain penalties, and then we have a whole series of statutes for that. And when we get to 1376, it is the statute for the unlawful access.
And I understand your point with respect to 1376, but 1303 says unless displaced by the provisions of this chapter, and then it is amazingly broad. The principles of law and equity, including a whole bunch of things, supplement its provisions. So I struggle a little bit with how 1376 is sort of carves out and excludes the entire rest of the universe, given that provision.
Well, I guess I look at this from the reverse. If the legislature meant to give broad remedies, it would have said, tenant has every right to every remedy under the sun. It doesn't. The legislature, when it did enacted 1376, had its limitations. And
Well, what
put
do we
those-
do with 33-1303, as Judge Thumma was saying, which is very broad? It says, unless displaced by the provision of the Act, the principle of law and equity supplant its provisions.
Well,
How would you square your argument that 1376 is exclusive with that provision?
Judge, in our view, the legislature has spoken and put it in the statute. I mean, it is, I understand there's two, but when we're talking about specific remedies, if the legislature had wanted it, could have written here, if it wanted something different, could have said, we're going to allow all remedies. Tenant can sue in equity, tenant can do anything it wants. It doesn't. It's very principled. I know it's broad to protect tenants, but when we come to this particular issue, it's very, very specific, and we have to follow the law. And if you don't mind, if I could save the rest of my time.
Excuse us. Yeah. Well, I'm glad you mentioned that. Thank you.
Thank you. I'm Benjamin Gottlieb for the appellees, Michael and Robin Anderson. As your judges have pointed out, there's been no transcript provided to the court in this case, and that's important not just to show that there's absolutely no record of any objection made to the jury instruction, but it's also important to point out that in the appellant's opening brief, the appellants make statements such as the factual findings are undisputed. They make statements that the judge misinterpreted the law. There's no record citations to those assertions. There's no ruling where the court stated how he was interpreting the law that's cited to in the appellant's opening brief. There's no ruling or transcripts or anything cited to show that the factual findings of the jury are undisputed. So that's just at the outset a glaring flaw that's observed in the appellant's brief.
On that point, Mr. Gottlieb, did the motion for summary judgment that discussed 33-1376 preserve the issue as to the jury instruction?
No, I don't believe it did. That motion was denied, and that's, in our view, that's not a substitute for the evidence that was presented at the trial. That motion was filed years prior to the trial. There was evidence submitted at the trial. There was numerous witnesses It's our view that the motion for summary judgment is not a proper substitute for the trial transcripts.
Well, it wouldn't be if we were talking about weighing the evidence and determining whether the evidence supported the giving of an instruction. But if, for example, it were a pure question of law as to statutory interpretation, would that motion for summary judgment suffice to preserve an objection to the jury instruction based on the statute?
Well, again, I mean, our position, as you know, is that we don't believe it's a pure issue of law. We don't believe that's the case. That's a different question than what's applicable here. I don't think the court needs to get into that question because based on what you've seen in the brief, our position is that there was clear evidence of a termination. So we don't have that situation here. We don't have a ruling where the court said, you know, I'm interpreting the statute this way, and therefore that's the only issue for the Court of Appeals, or that would be the only issue for the Court of Appeals to review. In addition, to reverse a jury instruction here, even if they did provide the transcripts, they would have to show that the jury instruction was erroneous and that it was prejudicial to the appellants. Again, the prejudice has to be shown affirmatively from the record, and the appellants can't show that here because there is no record, and so they just simply can't make that showing. But as was pointed out in the briefs, there was evidence of a termination, so I'm not sure what the appellants are getting at here. And to Judge Norris's comments, the interpretation, the proffered interpretation of this statute, 33-1376 by the appellants, just completely flies in the face of common sense. And as Judge Norris pointed out, you're going to have many situations where either the landlord might beat the tenant to the punch and try to terminate the lease first and sue for damages. Under the appellant's statutory interpretation, when there's a clear violation of 33-1376, the landlord gets to say, too bad, I beat you to the punch. You didn't terminate it before I did. Therefore, you don't get a remedy for our illegal entry of the property. And this argument's being offered in the context of the Residential Landlord-Tenant Act, which was enacted for the protection to provide additional protections to residential tenants because by law they're not deemed as sophisticated as commercial tenants, which is governed by a separate statutory scheme. And so the proffered argument by the appellants is not only it makes no sense, but it's also inconsistent with the purpose behind the act as well. Even if we do get into the statutory interpretation of 33-1376, there's nothing in that statute that says that the tenant shall exercise these two remedies, seeking injunctive relief or terminating. The word is may. So there's nothing that says shall. There's nothing in the statute that says that the tenant waives its remedy for an illegal entry. There's nothing that gives the tenant notice that if it doesn't do that in a particular manner, it waives its remedy under the statute. There's nothing in the statute that says it's the exclusive remedy of the tenant.
On that point, and I do understand your position that the Andersons terminated the lease, so I understand that. But put that aside for the moment. If we agree with you that the statute is permissive and that these are options, an injunctive relief or a terminate, that those are remedies, they're not exclusive. What I found confusing here is then let's assume a tenant in that position can just bring a claim for damages for basically violation of the covenant of quiet enjoyment, because that's essentially what's going on here. The court, however, instructed the jury that if it found the unlawful access, they were to award a minimum of 1 month's rent, which is clearly a tie-in to the statute. How can that minimum floor damage apply if a tenant has a right to pursue a non-statutory remedy?
Well, I think that the statute does not require, I think that to get the remedy under the statute, it does not require that you march into court and seek injunctive relief, or and it does not require that you march into court or to send a termination letter and to try to seek to formally terminate the lease.
Counsel, how do you get there given the in either case?
Sure, absolutely. Well, I think that what you have to do, first of all, I think at best case scenario, that would be an ambiguous term for the reasons I stated. There's nothing in the statute that says shall. There's nothing in the statute that says those are the exclusive
And
remedies.
I understand that, and you heard me question the other side about the application of 1303, but in either case is the last sentence of 1376B, and it comes right after the sentence that says, hey, you have one of these two options. So regardless of whether 1303 allows us to look to other law generally, with respect to the no less than 1 month's rent, tell me the path to get there unless it just applies to those two statutory provisions.
Sure. Well, I think what you have to do is you have to look at the purpose behind the act, and you have to look at the fact that this act was enacted to provide additional remedies for the tenants. And when you view it in that context, the legislature never intended that these would be the exclusive remedies. The legislature was intending that these would provide the tenant with some remedies, and it's given the tenant some options.
And I understand that, and that's kind of the 1303 question,
Sure.
But when you get to 1376B, it talks about two things that may or may not have existed at common law, although perhaps they did. And then it concludes by saying, in either case, you can get no less than 1 month's rent. The no less than 1 month's rent is a concept that I think was a stranger to the common law, and was brought into this context given the adoption of a uniform act. So help me again understand how the in either case doesn't limit that kind of unique remedy to just one of these two options.
I think in either case refers to the remedy that the tenant has. And it's not referring to the specific, you have to terminate the lease or you have to seek injunctive relief. I think it's viewed more broadly in the context of this is what the tenant gets when there's been an illegal entry.
And the better way for the statute, if that's the case, to read to be in any case as opposed to in either case?
You could make that argument, but I think when you look at the purpose of the act, I think when you look at the fact that like you talked about 1303, and when you look at the fact that this is an act that was protected, that was designed for the protection of residential tenants, and when you actually think about the application of the statute, there would be absolutely no logical reason why the legislature would want to preclude the tenant from getting that remedy in a situation where they didn't, rush into court and seek injunctive relief or formally terminate the lease. But I would submit to you that we don't even get to that question because there was a clear evidence of a termination here. And there's nothing in the statute that prescribes a manner in which you have to terminate the lease. So I don't think this court needs to get to the question of statutory interpretation. No transcripts were provided here. Under Arizona case law, the court must presume that the evidence supported the trial court's decision. There simply can't be shown any prejudice whatsoever if there was a clear termination.
We don't have the transcript. So when we adjourn and you go back to your offices and we are in our chambers, where would I look to determine that the Andersons, I know the letter, I've seen the letter, is that the only place I would look, that exhibit?
Well, I think there should be a transcript that would be the evidence. Again, I mean, this trial took place a year and a...
But we don't have the transcript.
Right.
So the only place I'm looking to see if the Andersons terminated the lease is the letter. That's it.
Well, that's all that's been provided to you by the appellant.
Well, I know, but the appellee also has a duty to provide the transcripts if it pertains or supports their arguments. This duty swings both ways, essentially.
Well,
And how would we know that the jury found? Where would I look to see if, in fact, the jury agreed that the Andersons had terminated the lease?
well, again, I believe that's the appellant's burden to produce those transcripts. Their premise on appeal was that the jury's factual findings are undisputed, and then they didn't produce any.
But the jury didn't make any specific factual findings. We don't have special interrogatories. We don't have special verdicts. So all we know is the jury ruled in Stefanovich's favor on certain on a claim, and in the Andersons on a couple of claims.
What I would submit to you is that the correspondence that you were just referencing, the August 7, 2012 correspondence, essentially says we're demanding our security deposit back pursuant to ARS 33-1321D. If you go to that statute and read that statutory section, it says after termination of the tenancy, the tenant can demand back the security deposit. I think it says that twice, and then in another section it says upon termination. Another part of the section says upon termination of the tenancy. It's very undisputed, clear evidence that the court does have at its disposal. And if I may, just because there's 8 minutes left, I wanted to switch gears to the secondary issue, unless the court has additional questions on the.
I think so.
Thank you. There's all this discussion on the attorney's fees issue with respect to ARS 12-341.01. I just want to really bring forth to the court the fact that there was a lease here that the parties entered into, and the language in the lease regarding attorney's fees is much, much broader in scope than the language in ARS 12-341.01. The language in the lease as it relates to attorney's fees, and I mean there's no dispute that this lease was entered into among the parties. The language of the lease states that the prevailing party shall be entitled to all of its reasonable attorney's fees arising from any dispute between the tenant and the landlord relating to the lease. That's much, much broader language. So I don't believe the court needs to get into the analysis of this de novo review of 12-341.01 if the court had a clear, sound basis for its ruling under the language in the actual contract, the lease. There can be absolutely no dispute here that these claims all arose from a dispute between the landlord and tenant relating to the lease. And I don't even think the appellant ever tries to argue that. The appellants focus on 12-341.01. And again, I think that statute applies if we get into that analysis, and I'm happy to do that. But
there a stipulation by the parties that the jury would be told that the case is a landlord-tenant dispute arising out of the lease of a furnished home?
That's absolutely correct, and that's in the appellee's brief, yes. There was a stipulation as well entered into, and it was read to the jury that this is a landlord-tenant dispute. And the appellant only raised this argument for the very first time after the jury verdict came in and after there were competing motions for attorney's fees filed with the Superior Court. That's the context that this argument first arose.
It seems to me the more interesting issue is whether there was an abuse of discretion in applying the prevailing party, in determining the prevailing party.
Well, I don't think there's an abuse of discretion at all. If you look at the case law, the Trollope case, as well as the Ocean West case, those case law principles make clear that when there's competing claims for damages, and that's exactly what you had here. You had competing claims for damages. The landlord was saying, hey, I've been damaged. The tenant was saying, no, we've been damaged. And you had competing claims for damages, and the jury ultimately awarded the tenant more damages than the landlord. And if you look at those cases, the Trollope case and the Ocean West case, they make clear that in a case for competing damages, even if you don't win your entire relief, even if the jury doesn't award you the full spectrum of relief that you've asked for, if you're the net winner, you're still declared the prevailing party. And so I don't see how there's any abuse of discretion as it relates to who was the prevailing party. I also think when you look at the settlement exchanges here, which I believe are very relevant, it just shows the disparity between the settlement positions that the appellants consistently took in this case and the ultimate result of the trial. The appellees actually at one point, just to avoid a jury trial, offered $5,000 to the appellants. And as stated in the opening brief, the appellants asked for $30,000. Then right before trial, they asked for $50,000. The case was virtually, you couldn't settle it due to the settlement positions taken by the appellants here. And I think the judge noted that in his decision to award attorney's fees. Unless there's any more questions, I'd like to reserve the remaining time for.
I I don't think you get to
All
reserve
right.
the remaining time, but feel free to wrap up.
Okay. Are there any other questions I can answer? So just to wrap up in summary, I don't believe as it relates to 33-1376 that the court needs to even get into the analysis of what does this statute require. The reasons for that are A, the transcripts were never ordered. There's no preservation of appeal. B, we don't know what was said in court. We don't know what evidence was presented in court. If there was undisputed evidence of a lease termination, and there's no transcripts, clearly the trial court's instruction would be correct in that case. And so for those reasons, the court doesn't need to get into that. If it does decide that it needs to get into that, there's absolutely nothing in the statute that would force the tenant to engage in these two remedies, lest it waives its remedy. It's inconsistent with the purpose behind the act, which was for the protection of residential tenants, and there's nothing in the statute that would tell the tenant that you're going to waive your remedy unless you do this. And finally, there's absolutely no prejudice to the appellant here, and the prejudice must be shown affirmatively from the record. There is no prejudice based on the lease termination, based on a correspondence asking for our security deposit back under 33-1321D. So with that, and then as for the attorney's fees, as I stated, the Andersons were the net prevailing parties, and the law is clear in that situation that they're the prevailing party. There's no abuse of discretion. That decision's made even clearer when you look at the relevant settlement exchanges among the parties. And so for those reasons, there was no abuse of discretion, and the lease language is very broad as it applies to the application of attorney's fees. Even if you decide to look at the application de novo of 12341.01, the parties stipulated that this whole case arose out of the lease. The lease was the central part of this case. None of the claims would exist if it were not for the lease, and the case law is clear in that situation that 12341.01 also applies. Thank you.
Thank you.
Let me go back to your earlier question about the record. The summary judgment motion at page 11, and that's in the record at number 39. And that's not an issue about the jury instruction, but it's an issue challenging the application of 33-1379, the either-or provision.
So is it your position that that preserved the objection to the jury instruction?
It didn't. It was before the jury instructions, but it's still our objection to the claim in and of itself. It's legally insufficient. But let me switch to the attorney's fees issue. And the abuse of discretion question is the larger question here. This is a very atypical case. Began in justice court as a small collections case, and then was faced with counterclaims dragging this case into Superior Court under threat of $70,000 and then $50,000. And those claims were all lost by the tenant. And those were large claims. And the landlord had to spend an inordinate amount of time and effort and money defending those claims. And ultimately, this thing at trial, it was proven that, yeah, this should have been a justice court case.
But, you know, up against an abuse of discretion standard, you've got a very high hurdle. Judge Ray heard the evidence. Judge Ray managed the case pretrial, and he determined that the net judgment rule would apply in terms of determining prevailing party. And so the question isn't whether we would have done the same thing. Maybe we would, maybe we wouldn't have. But could any reasonable trier of fact have done that? And the answer has to be yes.
Well, this case may be the odd case. This is a case where, you know, again, we have the plaintiff getting dragged out of the forum into Superior Court, and this case is then made into a giant case. The litigation goes on, and it didn't need to be. And I think that's a factor the judge didn't look at.
Well, he did look at it, and I know you disagree with
do.
his assessment that your client was the driving force behind it going forward, and I know you disagree with that, but that was his interpretation of what he had seen and heard throughout whatever period of time he managed the case.
We disagree because we didn't bring the claims. I mean, I think that's...
Well, but we have a lot of case law in this area, lots of cases, that even though You may not have brought, your clients may not have brought the claims. Nevertheless, the fee statutes, contractual fee provisions are designed to encourage parties to be reasonable in the litigation. And although your clients may have been the recipient of the claims, that doesn't mean that they could be unreasonable, or at least that's what Judge Ray determined. And getting back to Judge Downey's question, when our review is for abuse of discretion, and the net judgment rule is the general rule, I recognize it's harsh here. I'm struggling to say the court abused its discretion given Judge Ray was in the trenches, saw how this case was being developed, worked up, and worked over, and made those determinations.
He did, but Judge, mistakes are made, and I think this is one of those rare cases. And when you look at the claims brought, the position taken by defendants, and I say defendants, but it's the tenant, and they were utterly without merit. That's what the jury found. And, you know, we had a summary judgment that was denied on all counts, and then we went to an arbitration, and, you know, this case sort of went on and on. Yeah, it would have been nice to have been able to resolve this at an earlier point in the case. But what we have is, on the specific claims, like breach of contract, the landlord wins. A number of claims don't even get presented. The good faith and fair dealing, an unjust enrichment case, a claim. There was also another claim for failure to maintain fit premises. That didn't get presented. I mean, we had to defend against an inordinate number of claims.
You know, I think your argument would have far more traction, maybe so much not under the prevailing party, but determining the amount of fees on reasonableness.
Well,
but 12-34101 does not apply here. And the provision in the lease is very broad, as Mr. Gottlieb mentioned, and furthermore, it's stated in the mandatory, or using mandatory language, the prevailing or successful, I think it says prevailing party, shall be awarded reasonable attorney's fees.
the language is also very clear. It says the prevailing party in any dispute or claim. And if you look at the number of claims and who won which claims, those are certainly claims, a number of them were won by the plaintiff.
And that's fair, but you're not arguing the trial court couldn't have done this. You're arguing the trial court shouldn't have done this.
And abused its discretion in doing so, yes. Unless there are other questions, I think I've gotten as far as we've gone. Are there any other questions?
No. Well, we thank you for your
Thank
argument
you.
today, and we thank you, Mr. Gottlieb, for your argument. We'll take this case under advisement and issue a decision in due course. We're going to recess now so that the bailiff may set up the courtroom for the next argument. Thank you both.